Good afternoon, everybody, and welcome to our webinar on preparing for the GDPR. This month we're looking at the GDPR. We have just less than a year to prepare for this, and it's becoming a topic that many are turning to. So as usual, we'll be looking at the changes in the law, but we also aim particularly to give you some practical pointers to help you to prepare for this. So before we start, I'd just like to introduce ourselves. My name is Alison Blackhurst. I'm the HR Knowledge Manager at HR Solutions, and I will be leading the session today. And I'm joined by my colleague, Sue Watson, our HR Operations Manager. Good afternoon, Sue.
Good afternoon, and afternoon, everybody. I'm here today just to field any technical problems. Hopefully you won't have any, but if you do, send through a message through the side panel that you have on the chat section. If you have any questions about the GDPR, then please do send them through. It's unlikely we'll have time to cover them at the end of the webinar because there is an awful lot of information to get through. However, we will respond to you directly by email following the webinar. I am recording the session as well, and so we can give you a link to hear it afterwards if you want to send us a message if you would like that, and slides can also be made available on request afterwards. Okay, so thank you, and I'll hand you back to Alison.
So no furious taking of notes, because they will all be available afterwards. I do hope you're going to be able to bear with me on this this particular topic, because everyone I've spoken to so far today has been absolutely worn out because of the incredibly hot weather that we've been having at the moment. And GDPR obviously is quite a heavy-duty subject. And it is one of these things that we'll be giving you as much guidance as we can as we go through. But actually, so much of what you end up doing will depend on the nature of the activities that you undertake in your business and the steps that are proportionate and reasonable given what you're actually doing. So, you know, what is all of this about, first of all? Because GDPR is a word that's on an awful lot of people's lips, but why? Well, particularly, we had the recent security breach within the NHS, and I think that again raised public awareness of the issue of data protection, because apparently it wasn't just the NHS that was crippled, but nearly 100 countries are thought to have been affected by that cyber attack, and it disrupted banks and telecommunications companies globally. Now, that was a ransomware cyber attack, and ransomware is a virus which can take over any device or computer, and it freezes the files. And hackers then use it to effectively hold the recipient to ransom. So they're asking for money in return for access to your documents. But that's only the latest in a number of data scares. The amount of data that's being processed globally is huge. So perhaps it's unsurprising that we do get data breaches from time to time. And IBM, according to them, we create 2.5 quintillion bytes of data each day. And 90% of the data in the world today was created in just the last 2 years. So a phenomenal amount of data. And by that, what we're meaning are things such as social media posts, online shopping, Google searches, etc. All of this is stored somewhere, creating a huge amount of personal data out there. So data protection laws aim to protect the privacy of individuals whilst giving businesses the right to use that data. But our previous Data Protection Directive actually dates from 1995. So it was set in a totally different technological context to today's world. And many of the tools and devices that we commonly use today, such as smartphones and fitness trackers and sat-navs, they simply didn't exist when the first directive was written. So on 25th of May 2018, so in just under a year, a new e-regulation, snappily called the General Data Protection Regulation, and known as the GDPR, will replace the previous directive. Now, the GDPR will apply to all organizations that are based in or do business in the EU. That's irrespective of your size, irrespective of your sector. And what it aims to do is it aims to replace all of the different data protection laws and regulations and reporting requirements that exist across Europe at the moment with one single set of regulations and that one set of regulations will apply to all of the EU member states in exactly the same way. Also, those rules will apply to competitors that are based outside of the EU that provide services to individuals in the EU or who monitor EU data subjects. And because the GDPR is a regulation rather than a directive, it simply applies directly in the member states without there having to be any additional national legislation. So we voted to leave the EU, and obviously the negotiations started yesterday, but we will still be a member in May 2018, and therefore we will have to comply until such time as we do actually leave. But of course, any UK organisation that has part of its operation within the EU will have to continue to abide by the GDPR, and any other organisations that want to continue to trade with our EU neighbours will need to continue to comply with the rules that affect their data processing. So irrespective of what happens with Brexit, and the indications are that most people are going to want the GDPR to continue to apply to us, particularly when we've done all of this work to actually ensure we're compliant with it. But we need to be taking steps now to ensure that we will be compliant in a year's time. And until then, the current Data Protection Act continues to apply. Now, because the processing of personal data is an integral part of so many different business activities, please don't underestimate the scale of the task of all of this. The Information Officer is recommending that employers start preparing now. And even if you are fully compliant with the current DPA, then there will still be some changes. And for the ultra compliant people, the sort of things that I'm meaning to are amendments to policies and procedures relating to subject access requests, because they're changing, responses to breaches of the DPA, the information that has to be included on privacy notices, checking that we have the appropriate consent for retaining and processing personal data, because the rules on that are changing. And some employers may even have to go as far as appointing a data protection officer. So there is quite a bit to look at. Now let's just look a little bit at the background before we go into the detail of what we actually have to do. In many respects, the GDPR is very similar to the current Data Protection Act, and it aims to ensure that personal data is only sourced and processed for a legitimate purpose, that we're not keeping data beyond this, and that we're storing it securely. But it is more up to date, and it does reflect more recent developments such as social media, internet sales, mobile data, cloud storage, and also the increased ability to keep, for example, 2 or more data sets which need to be combined to create personal data. It places a lot more emphasis on the documentation that data controllers must keep in order to demonstrate their compliance. And it's written largely with internet consumer data protection in mind. It's not an HR piece of legislation, but of course it covers the processing of all personal data. So it does also affect employee data and the way we keep our HR records. Now, in summary, what it aims to ensure is set out on the bullet points on this slide. We're looking at increased transparency, i.e. individuals should know how their data is being used. Increased accountability, so data processors must be able to demonstrate their compliance. Enhanced rights of data subjects. Now that includes a new right to be forgotten and also the right to make free subject access requests. Consent to the processing of personal data must be freely given, and it needs to be explicit, it needs to be specific, unconditional, and also capable of being easily withdrawn. In terms of data security, organizations need to be able to demonstrate that they're collecting only the data that's necessary and that people are only accessing it as appropriate and that they are keeping that data securely. And if there is a breach, then there are new rules about the prompt reporting of serious breaches, which must be reported to the relevant supervisory authority and also in some cases to the individuals who are directly affected by the breach. And finally, there are increased fines for non-compliance, and these are major. We're looking at up to 20 million euros or 4% of global turnover, whichever is the greater. the core principles that are set out in the regulation are largely familiar to people who are familiar with the Data Protection Act, i.e. personal data should be processed lawfully, fairly, and in a transparent manner. It should be collected for a specified, explicit and legitimate purpose, should be adequate, relevant and limited to what you need, and also it shouldn't be kept for any longer than necessary. It should be kept accurate and up to date, and it should be kept securely. So nothing too new there. But what is new is, first of all, much greater rights for data subjects. So the rights of individuals whose personal data is being processed include, first of all, the need for their clear consent to the processing of personal data, unless you're processing this for another equally lawful reason, and we will talk a little bit more about that later on. They should have easier access to their personal data. They have the right to have that data corrected and also a clarified right to be forgotten, which basically means that a data controller can be required to erase all personal data promptly for those who no longer want this to be processed, provided there are no legitimate grounds for retaining it. The right to object to the use of personal data for certain purposes, right to data portability between data service providers, the right to lodge a complaint with the supervisory authority, as well as obviously to make normal court claims for compensation and liability. The new right to be informed promptly if their data has been hacked, if there is also a serious risk to their rights and freedoms, and I will say a little bit more about that later on too. And the right to have a decision of the Data Protection Authority reviewed by the National Court. And controllers must provide transparent information to data subjects on the processing of their data. And that information has to be clear and it has to be understandable. Now, in terms of the things that are coming in specifically with the GDPR, and the ones that caught my attention are, there are significant new obligations for organisations and new rights for individuals, particularly the requirement to keep clear records and demonstrate evidence of consent, and the fact that we now have to inform individuals of their right to withdraw their consent at any time, and they have the new right to be forgotten. Yeah. So let's have a look in a bit more detail about specific changes. Yeah. First of all, personal data and sensitive personal data. There are some changes to the definitions in that they're updated and broadened. So what you're used to still stands, it's just the additions. Personal data for most of us was data that could be identified by using somebody's name, for example, or an ID or a number, but a way of actually clearly identifying that person. Yeah, location data has now been added to that, and also genetic data is another addition to personal data. So it's a broader definition of what's included. Yeah. And when we're talking about identifiers, personal data doesn't have to have somebody's name stamped all across it if you can identify that person through an identifier. So that is, you know, things like IDs, numbers, or factors which identify that individual. So, for example, cookies on computer systems become online identifiers. And whilst an awful lot of larger companies, particularly internet companies, are using a practice called pseudonymization, what that is, it's storing data so that if you get the original data, it doesn't mean anything because you don't know who it relates to, and you can only work out who it relates to if you have another piece of data, another piece of information, additional information, which is stored separately. So you need both. So for example, with application forms, you take the name off the application forms and they're coded with a number, and you need the data code that actually ties that number to the individual in order to know who you're talking about. Now, processes like that are very good in terms of security, but even so, such separate data is still disclosable under a subject access request. Yep. And sensitive personal data, there are some minor changes to that as well, in that sensitive personal data now includes genetic data or biometric data. And if you think about what I was saying before about the old Data Protection Act been quite a while ago, obviously we didn't have so much genetic data or biometric data at that time. So sensitive data, biometric data includes your fingerprint, for example, or retinal scanning. In terms of data protection officers, all public authorities and also any organizations which are involved in processing personal data as part of their core activities, which involve regular or systematic monitoring or processing on a large scale of sensitive personal data, that being data which is related to health, racial, ethnic origin, or personal data related to criminal convictions and offences, all of these organisations will be required to appoint specific data protection officers. Subject consent, well, data privacy notices are going to have to be more detailed. They will have to be given in advance so that when people consent to data processing, they are being given the data privacy notices. So they need to be concise, they need to be transparent, intelligible, easily accessible, and written in clear and plain language. In terms of subject access requests, well, the rules about that change. It's interesting because we actually haven't had very many subject access requests. Maybe we've been very lucky, but it hasn't been a common feature of our activities, whereas I understand that a lot of the local authorities are dealing with subject access requests on an incredibly regular basis. Now, the changes to these are, first of all, we're going to have to comply with the subject access request within a month of receipt rather than the current 40 days. Now, that month can be extended to 2 months if the request is particularly complex, but there's no definition of complex. And also, organisations are no longer going to be able to charge for complying with the request unless the request is manifestly unfounded or excessive. So your £10 fee goes out of the window. Data subjects should be given a copy of the data they've requested, and they should be able to exercise the right easily and at reasonable intervals, which implies that they can make multiple requests. And when employers provide the data subjects with the information they've requested, they also must provide details of the data retention periods and the right to have any inaccurate data corrected. Now, in terms of sensitive personal data, especially relating to criminal records, the lawful reasons for processing criminal records largely disappear unless any additional national laws permit this. So there may be some changes to background checks and investigations, but we can't give you any more information about that at the moment. The right to be forgotten is a new thing, and also the right to have inaccurate data rectified. That was there before, actually. And record keeping is expected to increase significantly, firstly to ensure compliance, such as privacy impact assessments and audits, and also to defend any instances of non-compliance. And I did mention the penalties before, simply because they are so huge, but the fines for non-compliance are the 20 million euros or 4% of global annual turnover. That will only apply to serious breaches, and that's such things as the failure to have a lawful reason for processing the data, or someone who transfers the data to a third country. For lesser breaches, such as some of the processor, security and administrative related breaches, we're looking at fines of 10 million euros or 2%, whichever is the greater. But one thing which is worrying is it appears the fines may be levied without having to demonstrate any harm. So largest compensation will logically apply to cases where the data subjects have directly suffered some damage, but they don't have to demonstrate harm. It's just they have to demonstrate a breach. And individuals can claim compensation from the data controller or the data processor for non-compliance. And they can claim not only material or non-material damages, they can claim compensation for distress. And data subjects may be collectively represented by not-for-profit bodies when making claims. So consumer organisations, for example, are going to be able to bring class actions against organisations that infringe the data protection rights. So we've covered what's going to happen. How do we actually start to prepare for all of this? Well, firstly, I think it's a case of considering, well, what are the main risks that we face here? Clearly, the possible fines are huge and could potentially put firms out of business, but they are probably going to be few and far between, hopefully few and far between. Yeah. What is going to be far more common in most cases is that the removal of the £10 fee for subject access requests may end up in you receiving lots more requests. And if you don't have good practice in data storage and retention to start with, and if you don't have a good proper process for dealing with these within the tight time scale, then you could end up facing costly action, and as well as an awful lot of administrative time spent scurrying around trying to get everything right. Yeah. Companies that retain data for marketing purposes are going to have to take special care to make sure that they're not breaching the consent rules. So, I may have consented to you sending me information about a particular product, but not about lots of other products, and not for you to share my data with other organizations. Yeah. And organizations that process lots of personal data, including ourselves, of course, and organizations such as recruitment agencies and executive search are going to need to be particularly careful given the increased risk of subject access requests from disaffected candidates. And finally, I've put reputational damage as being one of the main risks there, because I think this is in line with a lot of the other topics we've covered recently, like modern slavery statements and gender pay gap statements. We don't want to be the ones in the media spotlight for all of this. So the GDPR will impact on how you do business, irrespective of whether you're in the private, public or third sector. It will impact on how you process information, particularly if you do it through a website, how you deal with your customers and clients and those who sign up to your marketing and sales activities, how you respond to subject access requests, how you manage HR processes, not just for employees, but also for candidates and for leavers. And also it will impact on your relationships with any external organizations that process personal data on your behalf. Now, if you've always taken data protection very seriously, and you rigorously prune your records, and you have really tight security levels in place, then you may find actually that any necessary changes are fairly minimal and it's just a tweak to some of your documentation. But in reality, many of us are aware of at least some weaknesses in our systems. Typically, we retain information for much longer than is necessary, or we may have used it for purposes other than that for which it was originally provided. Or we know that we have some employees amongst our workforce who really aren't as strict with security or password control as our policies dictate. So perhaps this is a good opportunity to really assess what data we're keeping, why we're keeping it, how long we're keeping it for, how secure it is, and whether we dispose of it securely and take appropriate measures to ensure that everybody is following the rules that we're putting in place. An awful lot of this, of course, is simple good practice, but it might not always have been at the forefront of our minds. So where do we start? We have a little action plan for you. We've got 12 steps, just so, so you're aware. And step 1 is to assign responsibilities and set up a working party. Probably unsurprising, really. First of all, check who is responsible in your organization currently for data protection compliance. That could well be your finance manager, your HR manager, your office manager, or somebody who actually has no real idea as to the amount of power that they now have and the amount of responsibility that they're taking. You will no longer need to register the data controller with the Information Controller's Office, and everything that data controllers have been responsible for to date still stands, but they do now have much greater responsibility in that data controllers are now required to demonstrate compliance, to be responsible for implementing appropriate technical and organizational measures to ensure and demonstrate compliance, to ensure that when you're planning process activities and implementation phases, you're taking data protection principles and safeguards into account, to keep records of processing activity, to be responsible for data security, and also to be responsible for deciding whether any breaches should be notified and for doing so. Now, is your current data controller fully aware of the increased responsibilities and the forthcoming changes? Secondly, check whether you're required to formally designate a data protection officer. Now, this may not apply to you, and the requirement isn't as wide-ranging as was first thought, but if you fall into one of the categories that I mentioned earlier, then you're going to need to appoint a data protection officer. And that person should be an expert in data protection law and should report directly to senior management. They're going to be the ones that are responsible for advising on data protection obligations, for introducing your policies and procedures, for monitoring them, for training staff, and for carrying out audits typically. And our third suggestion is to set up a working party on this, basically because this is not just an HR issue, nor is it a payroll issue, nor is it just an IT one. All of the functions within your business that process personal data in any way are going to be affected and may well need to change some of their processes. So you need to ensure that marketing, sales, finance, supply, payroll, etc., that they're all involved and become aware of the issues involved. Once you have your working party, audit your data. So have a look to see what personal data is kept, by whom, why you're keeping it, where you got it from, and where you're storing it. Now, personal data is not just personnel records in old-fashioned parlance or HR records. It includes all personnel data, including client customer details, marketing databases, sales records, everything like that. And the GDPR states very firmly that organizations should not collect data that is not necessary for a specified purpose that has been notified to the data subject in advance. So collecting personal data and then deciding what you're going to do with it is simply not allowed. So what do you keep and why? And do you really need all of this? Clearly, you're going to need to have records, as we said before, and documented evidence to show that you're compliant, but also clearly there is going to be less likelihood of a breach if you start to reduce the amount of unnecessary data that you're keeping on file. So yes, you need clear audit trails. Yes, you need documented procedures to demonstrate your compliance. But it may also be worth, when you're looking at what you keep, thinking about how can we minimize the amount of data we hold? Do we really need that? And if you don't really need it, then get rid of it. Clear guidelines on what you keep and for how long, and ensuring that your data is pruned accordingly. So a clear retention or destruction policy may help with this. And it also may well be worth looking at some automated forms of data destruction. And what we mean by that is, for example, records which are deleted automatically off your IT systems and your backup procedures after a specified period of them not being used or referred to. If you're keeping lots of hard copy HR files, then obviously it's a case of how do you actually ensure that you're not keeping data for longer than you need to with all of those. Who has access to the data? Check for each system or service who has access to what data, and how are you going to track access and other activities and know whether it's specific individuals that have been accessing the data. So bearing in mind that the chances are you could well face an increase in subject access requests, and when you do, you're going to need to be able to access all of the relevant data across your business. So the last thing you want are managers who are keeping multiple copies of the same information in different places. You're going to need clear backup procedures, and also to be able to check that the data is only released to those who need it. And we do see quite a lot of examples of people having access to sensitive personal data when they don't actually need to know that. And an easy example is, for example, payroll. If you send the sick notes through to payroll in order for them to process sick pay, they do not need to know the reasons for somebody's absence. They only need to know the dates of absences. I mean, that's a simple example, but you need to think who is accessing sensitive personal information in particular.
And have a look, again, in particular, to email traffic and the need to minimize this where possible, because this is an incredibly risky area for the simple reason that it's so easy to forward emails on to multiple recipients and end up in breach of the requirement for confidentiality. Now, where did the data come from? You may well think, well, does that matter? But yes, it does. You need to be aware of the source of the data. If you have incorrect personal data and you've shared it with another organization, then under the GDPR, you are required to tell the other organization about the inaccuracy so that it can correct its own records. And obviously, you're not going to be able to do that unless you know what personal data you hold and where it came from and who you share it with. Now, also look at where are you storing this data, because that again is going to be necessary to be able to deal promptly with your subject access requests. So how many different locations and environments does this data reside in? And what we mean by that is geographic locations, obviously, but also locations within a data center or cloud environment. And for cloud services, where is the data center? How is the data stored? How many different data types need to be secured? Where does it get transmitted to? It would be very sensible to minimize the data locations wherever possible, especially when you're looking at sensitive data. Now, this could be a huge task, as you're probably thinking, your head's probably spinning at this point and you're thinking, oh my goodness, I could do without this. So I guess really the focus initially should be on the key areas of risk, those where the GDPR brings in new obligations, and I'll be talking right at the end of this webinar about children's data. That's a particularly new area, may not apply to you. But also, as well as the new obligations, also those which present greatest risk to you. So possibly large-scale processing of sensitive data, activities such as automated profiling, where you're, for example, determining whether people get finance from online applications, or where you track browsing habits to offer discounts, or automated online recruitment, that sort of thing. And any systematic monitoring such as IT network security monitoring or CCTV monitoring data. All of those are widely recognized as risky areas, so concentrate on those. Step 3 is actually assessing the basis on which you are actually lawfully processing the data that you've got. Yeah, because for a lot of it, you will need to check whether you have the requisite consent. But for some of your activities, you do not need consent because the legal basis on which you process different types of personal data will include with consent. And if you're processing with consent, then the consent must be freely given, specific, informed, and unambiguous. But you can also process personal data for other reasons, other lawful reasons, and they include contractual necessity. Now, that basically what that's saying is you need to process this data in order to perform a contract which the data subject is a party to. So, for example, processing credit card details for payments. You can't actually deliver the contract if you can't do that. Yeah, processing addresses so that goods that have been bought online can be delivered. That would fall under contractual necessity. So you don't need consent if you've got contractual necessity. Compliance with a legal obligation, for example, keeping tax records. You don't have any choice as to whether you keep those or not, so you do not need consent to keep those records. Yeah. The vital interest of the data subject is a bit of a rare one, and essentially really it applies to life or death scenarios. Public interest wouldn't apply to private companies. That basically is saying, look, it's necessary for us to process this data for the performance of tasks which are carried out by a public authority or a private organisation acting in the public interest. And then there is legitimate interest, which is quite a useful catch-all and obviously a more risky one. But if you identify the legal basis on which you're processing all these different bits of data, then you may well find you don't need consent for all of them. So document this and update the information that you give to data subjects to explain the basis on which you're processing the data. Now, privacy notices typically identify you and they say how you're going to use the data, but also now you're going to need to explain your lawful basis for processing this, and you also have to inform the data subject of your data retention periods, i.e. how long you're going to keep this data for. And also you have to tell the data subject that they have a right to complain to the Information Commissioner if they think there's a problem with the way their data has been handled. So that will need to be added to your privacy notices. Where you are processing with consent, and typically actually this isn't going to be so much employment scenarios as is more likely for things like marketing activities and sales activities, yeah? So for that you will need to review how you gain consent, how you record it and how you manage it. And this has to be via a statement of clear affirmative action. So consent means an active opt-in, for example via a tick box or a signature. Silence or giving people pre-ticked boxes of consent or inactivity will not confer consent. And the consent has to be separate from any other terms and conditions that you're handing out. And also, particularly for things like marketing activities, it's recommended that you take a segmented approach to this. And what that means is splitting out your activities into separate sections rather than relying on one global overall consent, yes, so that your data subjects can opt into the bits that they do want to receive and can opt out of the bits they don't want to receive. The name or organization to whom any data will be passed on to should be specified. And also, you need to include a transparent opt-out system, which has to be readily available at all times. So if I've given you consent to send me marketing information, I need to be able to get in touch with you at any time and say, right, I've had enough, I don't want any more. Yeah. Also, you need to tell individuals about their right to be forgotten and that they have the right to have their personal data deleted. And that information should be provided at the time that you're collecting the data or as soon as possible thereafter. And it needs to be concise, transparent, intelligible, easily accessible, and written in clear and plain language. So it might be worth looking at your documentation now, because obviously that's something that you can amend easily now and start to get into your systems. Have a look at your existing consents, yes, and check that they comply with the new requirements, because if they do, they'll continue until the activity finishes when they would normally expire. But if they don't, then you're going to have to get fresh consent from all of your clients and your contacts, yeah. And records of consent must be kept so that if you have to, you can demonstrate evidence of this. Data subjects can object to their data being processed, and if they do, then the processing must cease until the data controller can show compelling grounds for continuing it, or the data controller can show that the processing is necessary in connection with its own legal rights. And if the data controller can't show one of those two grounds, then it has to stop the processing. And if you're gaining consent for online activities, you will note that many websites now are going to have to turn cookies off by default and only start capturing browsing data after visitors to the site have explicitly agreed to let them do this. You may well see that coming in. I've noticed that increasingly on online sales sites, yeah. But by requiring this consent before a business can process personal data for profiling reasons, the GDPR is going to make big data analytics much more difficult for many organizations. So consent is a big issue. And in many cases, if you can rely on contractual agreement or legitimate interest for lawful processing, that may well be a far better approach for some of your activities. Okay, so you've decided what you're going to keep and how and when and how long for and who's got access to it. The next thing is to consider data security. An awful lot of the expensive fines and the bad press coverage have related to breaches of security rather than complaints about what you're keeping or whether the data is incorrect or it's out of date, for example. So it is key to ensure that your security systems are robust enough to prevent disclosure of data to unauthorized recipients. So where are your main areas of risk here? Is it your systems or is it your people? Now, if it's your systems, you might want to consider using ethical hackers or other security testing for the former. If it's your people, you may well need to look at more training, and we'll talk a bit about that as well. For systems, consider data encryption services, look at things like secure key management. If you have that, then that may well avoid the need to report a data breach if the data is absolutely unintelligible and inaccessible unless you have that key. And that may well also help in terms of the right to be forgotten, because by deleting a key that is associated with a consumer's records, a business can ensure that the encrypted data will never be accessed in the clear. A lot of organizations, as I said earlier, are using pseudonymization. But I mean, obviously, if you're going to be doing things like this and it's a new procedure, it's going to take you a while to get that embedded and have everybody trained to do so, which is another reason for saying, look, start to think about this now. Don't leave it until a year from now. Consider retention and destruction of data. Yeah. There are now some specific provisions in the GDPR that apply to the processing of personal data for historical, statistical, or scientific purposes, and those are subject to appropriate safeguards. But for most of us and for most data, it's a case of reconsidering retention periods in the light of the new right to be forgotten, because data subjects may well ask you to erase their data sooner than the end of your normal retention period. So you can't turn around and say, oh yeah, that'll be wiped off our system in 6 months' time. You've got to act more quickly than that. So the right to be forgotten applies an awful lot in terms of things like social media and came out of Google, and rather than thinking about employee data. And it's the right for data subjects to have their records and personal data erased where there is no legal ground for retaining it. So if you have a legal ground for retaining it, like your payroll records, then provided you're sticking to the guidelines on data retention for those, obviously you will carry on doing so. Yeah, but the right to be forgotten also applies to data that's processed on your behalf by other agents. And data subjects can object to the accuracy of their data, and the data has to be removed while it's investigated under the right to restriction. So if an individual asks for the personal data to be deleted, can you do that quickly? Can you locate and delete that very, very quickly? How long do you keep your data for? And how do you actually ensure that it's not retained beyond this time by any of your employees, including home workers on laptops who are keeping things on their hard drives, for example? Can you store that data in such a way that it is easier to automatically erase it at a certain time? We're looking, for example, at things that will wipe out files or folders on our cloud storage system if they haven't been accessed for 6 months, so or a longer period, depending on what it is. I mean, anything that automatically does that pruning for you is going to help you. Clearly, hard copy files are much more time intensive in the sense of pruning this. So have a look at in terms of HR, have a look at the personal data that you keep when somebody leaves your employment. Clearly, you're going to need to keep some information if you are to provide references or information about pension arrangements, for example. But if you have lots of personal data that's unlikely to be needed again, remove it when somebody leaves, yeah, or within a certain timescale after they leave. Recruitment, again, also may be a particularly risky area because of discrimination claims for non-selection. So it may be worth storing and recording things in time sequences rather than particular activities so that you can actually prune much more quickly. And note that the right of erasure doesn't just apply to current databases and current files, it also applies to backups and archives, etc. So it's not necessarily an easy task. Now, dealing with subject access requests, I've used the Sherlock Holmes picture there just because so many people that make subject access requests are doing so because they may well be thinking about, is there something here that I can use against a company? Let's find out a little bit more information here. Because the £10 fee is now going, subject access requests are likely to be more frequent. And you also need to be prepared for a shorter timescale for dealing with them because we're looking at a month rather than 40 days. Now, the £10 fee usually actually gave a lot of people more time to prepare, because a data subject would make an initial approach, would then be told to send in their request and the payment, and that gave you a few more days before you got the payment. It also would put off quite a lot of people because they simply wouldn't bother if it was too much hassle. It's not going to be hassle anymore. Yeah. The 1 month timescale is fairly tight. It can be extended to 3 months for complex requests. We don't have a definition of a complex request, but if you are going to have to go beyond the 1 month timescale, then you need to inform the data subject of the delay and the reasons for it, and the fact that the data subject has the right to complain about that. So organizations may make a charge if the request is manifestly unfounded or excessive, and the charge could be reasonable administrative requests. You can also refuse to act on a request, but you need to be able to provide evidence of how you've actually come to the conclusion that the request is manifestly unfounded or excessive. And you also have to tell the individual why you're refusing the request and that they have the right to complain. So very few people are going to do that. Yeah. Data subjects can ask to have inaccuracies corrected, they can ask to have information erased, or they can ask for direct marketing not to be sent without consent. They can request a copy of the information, and they should be told whether any personal data has been processed, a description of the personal data, the reasons it's processed, whether it's given to any other organizations or people, such as third-party outsourcers, and how long you're going to keep it for. And they also need to be given details of the source of the data, where it's available and where you've got that data from someone other than the data subject. And as with the Data Protection Act, data subjects can view their own personal data, but not that relating to other individuals. And data controllers can still withhold personal data if disclosing it would adversely affect the rights and freedoms of others. So, look to see whether you can manage requests within the shorter time scale. Can you identify and isolate all copies of all personal data relating to a particular person? Make sure you have a defined procedure for handling requests, because that timescale runs from the receipt of the request, not the receipt by the person who's going to be handling it. Yeah, and failure to provide employees with or anybody with access to the data they've requested could result in a significant fine. And also check your systems to ensure that you can quickly rectify any inaccurate or complete data without undue delay. From that point of view, might it be better to actually have more checks that help you to ensure that your data is up to date anyway? Yeah. And if you have inaccurate personal data and you shared it with somebody else, you will have to tell the other organization about the inaccuracy. So in HR terms, that's pension providers, benefits providers, insurance companies, all that sort of thing. Can you quickly erase the data if you're requested to do so? Consider your pre-recruitment checks. This is a quick point, actually, because there's not too much more we can say about it at the moment, but do check that if you're undertaking any background checks or criminal record checks, first of all, that they're necessary, secondly, that they're being conducted properly, and also if you use third parties for this, ensure that they're retaining the appropriate levels of confidentiality and security. Now, once we've done all of that and looked at our systems, we need to look at employees and check their equipment as well as their own activities. Yeah. Microsoft's guidance makes a very clear point, which I particularly like, saying amateurs hack computers, but professionals hack humans. Because we all know of managers who, put passwords down in writing, or they use the name of their dog on every occasion. And we are now increasingly asked for so many passwords for so many different things that the temptation obviously is to use the same password for more than one application. Therefore, if you've got the password for one thing, you can use it for lots of others. So it's a case of raising awareness of the GDPR so that people are aware of the changes and the impact they'll have, and to ensure that people who do process personal data understand their obligations regarding confidentiality and security. Many don't. And many don't care either. A few years ago, there was a survey that Office Angels, the recruitment agency, ran, which was finding out how much would it cost to get you to tell me what your password is. And they were horrified at how many people were quite happy to disclose a password for a Mars bar. So, it is a case of looking at that very carefully, at updating policies to reflect the new rules on subject access requests and content and notification of breaches, but also training your employees of inadvertent breaches of security. Because at the end of the day, you can do what you like in the sense of sophisticated, robust security measures, but unless your staff know what to look for and the consequences of their actions, then actually they can amount to very little. Now, there is a huge amount of free guidance out there which you could use in your training activities. A lot of the major banks and insurance companies and also a lot of internet providers have been issuing basic guidance covering things like antivirus, malware, opening attachments, scanning attachments, don't follow links in emails, all of this sort of thing, all of which is very, very useful. So, do make use of it and ensure that your employees are aware of the risks and that apply with any requirements regarding robust passwords, dual authentication, all of that sort of thing. Once you've trained them, also do check their equipment and ensure that security software is installed and up to date and that they are running updated software on their systems, including the operating system and plugins. Anybody running XP, for example, should download the emergency Windows XP patch. Check your backup procedures and do make sure that everybody knows that if you are hit with a breach of security, immediate action should be taken to shut down the network. Now, once you've looked at your own organisation and what you're doing, consider any outsourcing or partnership arrangements, check who else processes your data and where. Have they implemented appropriate security measures? What are they doing to protect you? Do they have robust practices? Do they conform to internationally accepted standards? Can they demonstrate that they have a culture of security? What are they doing to help you manage your data and to meet your obligations? Are your supplier contracts fit for purpose? You might want to look at penalties and liabilities in case there are any breaches on their part. And bear in mind also the GDPR includes a new right to portability. Now that's Article 20 for those to whom it applies. And what we're talking about there is providing data in a structured, commonly used machine-readable format so that it can be transferred from one data controller to another, which typically will apply to organizations such as insurance companies where policy details are being transferred, that sort of thing. If that applies to you, check the details. Check your documentation, but that's becoming obvious by now. So make sure your privacy statements are correct and that they have all of the required information. Look at any written security procedures that you have. Are they up to date? Are they given to all processors? Look at your data protection and data retention policies. Look at any clauses you have in contracts and any penalty clauses in supplier contracts, etc. Now, we will be updating a lot of our template documentation on this, but to be honest, it is a difficult thing to do once you go beyond outlining what the regulations say, because a lot of these procedures are going to be specific to your business and the nature of your organizations. And for example, we tend to find that the IT policies are the ones that are most commonly tailored to organizations and have the most unique things in them. Data protection is going to be one that falls within that remit now. Step 11, once you've done all of this, monitor it and review it to check that everything is working the way it should be. Yeah. And you need to keep internal records of the processing that you're carrying out, including the name and contact details for processors, controllers, and joint controllers. Yeah. So do your processes give you clear audit trails? Do you have records which can clearly demonstrate that you're complying with the GDPR? And what are you going to do to monitor it and to tighten up if necessary? Step 12, we're nearly there. Notifying breaches. Yeah. Now, new rules apply regarding security breaches, and a data breach is more than just the loss of personal data. So it can include any breach of security that leads to accidental or unlawful destruction, loss, alteration, unauthorized disclosure of or access to personal data that's been transmitted, stored, or otherwise processed. Data security breaches are increasingly common, and they can be caused through human error or malicious intent. So we've put some examples there on the slide for you. I think they're fairly obvious, actually. I think you have to note that an awful lot of these offences, though, are created by human error. People leaving things on trains, or talking where they can be overheard, or disclosing personal details to the wrong people, or sending emails to the wrong addresses, copying people in when they shouldn't be. Now, if you have data security breaches, obviously they're going to vary in impact and they're going to vary in risk depending on the content of the data and the quantity of data involved. But it is important to act very quickly to identify the nature of the breach, the type of data, the severity of the risk, and to respond to all reported incidents in a timely manner. Now, serious breaches may need to be reported to the Information Commissioner's Office without undue delay, and what they mean by that is at the latest within 72 hours of detection. So, and a serious data breach is one which could cause significant threat of harm to individuals, where you've got large volumes of data or where you have sensitive personal data. Yeah. Where a breach is likely to result in a high risk to the rights and freedoms of individuals, the data controller also has to notify those concerned directly in most cases. So if it could result in discrimination or damage to reputation or financial loss, then you're going to have to let the person know. I don't have an awful lot to add to this slide particularly. I think it's self-explanatory really. Ensure that you have appropriate procedures to detect and investigate on any personal data breaches, and think about having a policy that sets out how you will handle any breaches. So who they're reported to, who will investigate it, who will take steps for containment and recovery of data, who assesses the risk, and who actually reports it to the ICO, and who takes charge of that. Now, I know that we're coming close to the end of the time, and thank you for staying with me so far. There are just a few specific issues that we need to cover very, very quickly. Everything that I've said so far relates to everybody, all organisations, but some of these categories will not necessarily apply to you. First of all, information relating to children. There are new rules on that, new protection on that, and this particularly applies to social media and commercial internet services where you're offering online services to children and you're relying on consent to collecting information about them, because you may well now need their parents' or guardians' consent in order to process that data lawfully. So that applies to anyone under the age of 16. So if it's likely to apply to you, you need to check. Do you know your individual's ages? Do you obtain consent for anyone under 16? Do you need to review your privacy notices so that actually somebody who is somebody who is between 16 and let's say 21 can understand that very easily. If you're sending information internationally, then you're going to need to work out which supervisory authority is going to be the lead data protection authority for you. Yeah. And finally, data protection impact assessments. Yeah, these are mandatory where data processing is likely to result in high risk to individuals. So if you are using a new technology, if a profiling operation is likely to significantly affect individuals, or where you're processing on a large scale the special categories of data, you will then need to have a data protection impact assessment. And if there's a high risk, then it may well be that you need to check with the Information Commissioner's Office that your processing operation does comply with the GDPR. Now, are we doing all of that? You might well think, and the answer is yes, we are. And please don't underestimate the scale of the operation and the amount of detail that you end up having to go into to actually ensure that you are taking all of the steps that I've discussed. If you'd like further information about all of this, then the regulations can be downloaded in full. There's 88 pages of them, yeah. But also more user-friendly is the Information Commissioner's Office, which has a separate section on its website about the GDPR. It has an overview, it has it gives you the background to the reform, and it also has published 12 steps. They're not quite the same as the ones I've outlined, yeah, to take now to prepare for the GDPR. I note that we have 1 minute to go before the hour is up, so I do apologise. I'm not going to be able to take any questions on this. And the problem is most of the questions that you're likely to raise are going to be very specific to your organisation, I suspect. And it may well be that we don't have the answers to all of them either. But if you send in your questions, we will do our best to answer them. It might not be before next week because of a number of activities that I'm involved with personally over the next few days, but we will get back to you. So I would like to say thank you for attending this afternoon's session. I do hope you found it useful and informative. We will have copies of the slides and a recording available soon. And also we'll have an article which includes all of the additional information to the slides. Our next webinar is planned for Tuesday, the 25th of July, and we're planning at the moment to look at pre-employment checks on that one. Subject may change, but if it doesn't, then whatever we choose, hopefully it won't give you quite so much to do as today's have done. So thanks for bearing with us, and hope you have a good afternoon. Thank you. Bye-bye.